The next matter to come before the court is John G. Parker versus Pamela Parker. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, let me know when you get started, as I am keeping the clock and will keep you advised of passage of time. The court has read the briefs and we are ready to proceed when you are.
Good morning. May it please the court, I'm Arthur Axner, and I represent John Parker, who is the appellant in this case. There are essentially two issues before the court as it relates to this appeal. One of those issues pertains to the award of spousal support that was made in this case, and the other is pertaining to a division of property, specifically two sums of money that one is in an account and the other is in my account by order of the court. I submit on the issue of spousal support that the trial court did abuse its discretion. First off, an amended counterclaim was filed on March 14, 2012 by the appellee wife. There was no demand in that amended counterclaim for an award of spousal support. Civil 8A requires that a pleading that sets forth a claim for relief must set forth a demand for judgment for that relief. And the Revised Code Section 3105.18 provides essentially that in a divorce proceeding, and upon a request of either party, the court may award reasonable spousal support. I submit to you that since Pamela did not request an award of spousal support in her amended counterclaim, she is not entitled to that award. It should be noted that at the conclusion of the case, no attempt was made to amend the pleadings to make them conform to the evidence. Also, with reference to the spousal support issue, the trial court became aware during the pendency of the case that both parties had been discharged from their respective employments. John was discharged from Kuzman's Cleveland Inc., from which he had an annual salary of $52,000. Pamela was discharged from her parents' corporation, DJL Incorporated, and they do business as Country Lakes Party Center, and that's in Broadview Heights. John was discharged for poor performance. Pamela was discharged because she had a disagreement with her parents as to how the business should be operated.
Does it make any difference to this case why they were discharged?
Yes, it does, in the sense that the court later found that my client was voluntarily underemployed,
Okay.
and that they made no findings with reference to Pamela.
But they did, in fact, but didn't they? I mean, there wasn't there a statement that when the court did the calculation, it did come out that they found her earning ability to be $36,785 per year, even though she was only actually earning at that time.
That's what she was earning when she got her new employment at the hotel here in
It
Akron.
says she was earning annual income of $33,012. So $33,000 was what was projected to be her annual.
What had happened is that Mr. Parker could not find employment. He worked for the food terminal in Cleveland, and he tried to get another job. This is what he had done most of his adult life, and then no one would hire him. So he took a job in Marshallville, Ohio, doing labor work for a sand and gravel pit, as I understand it. And the benefit of that was that he was provided with health insurance for his entire family without having to pay any premium for that. And that was important during the pendency of the case. Unfortunately, his income was drastically reduced. He was paid on an hourly basis. At the time of trial, the wife's income was $33,010.12. and John's was $16,640. I submit to the court that the trial court became conflicted in analyzing this because in one instance the court made a child support calculation. And in making that calculation, I'm going to read what the judge wrote. There is not sufficient evidence before the court to impute potential income to either party for the purposes of calculation of child support. So the child support obligation was based upon both parties' actual income.
Was part of the reason the court did that because if they had used the imputed income to do that, there would have been arrearages every month that would have been accumulating?
If they had imputed income to both parties, the child support amount would have been different. No question about
It
it.
would have been way more than
Yes,
it currently was, and
Yes.
that it was established to be on the child support worksheet.
that's correct.
And it probably would have exceeded the percentage of his salary that's permitted to be deducted for child support purposes.
That's right.
So there would have been an ongoing arrearage accumulating over time.
That's correct.
Okay, so then the court, in order to prevent there being an ongoing arrearage, calculated it based on what they were currently earning at the time. Okay.
The conflict is, that I see in this proceeding, the judge specifically found that John was voluntarily underemployed for spousal support purposes. Having said he was not voluntarily underemployed for child support purposes, the judge turned around and made that finding with reference to spousal support. And I submit to the court that imputing income for spousal support purposes is not recognized by both statutory or case law. I believe in doing that, the trial court abused its discretion. If we analyze it, I'm sorry.
Let me ask you a question. By the court not imputing current, whatever, by not putting the proposed numbers, I don't forget the word right this moment, on the child support worksheet, there'd be no accumulating arrearages, which means that he wouldn't be jeopardize his driver's license or anything else by not paying it, right? But under spouses, if they do it for spousal purposes, then it wouldn't matter if there was accumulating arrearages because there wouldn't be any jeopardy to his current employment. Okay.
That's right, yes. And I took the liberty of calculating out if part of the abuse of discretion is that the award of spousal support from the husband to the wife represents 43% of the money he was actually earning at the time of trial. And that percentage would be greater if, once you look at the income tax situation. And it just doesn't make sense to me that an award of spousal support was appropriate and reasonable under the circumstances. The appellee wife was making more money than her husband, yet the husband is obligated to pay spousal support to her.
Eventually.
No, it's part of the divorce decree.
I understand, but he wouldn't be able to pay it because he wouldn't be able to attach more than a certain percentage of his income because he's only making $16,000 a year right now. But at some point in the future, the arrearages would come up to bite him.
The other issue is pertaining to property division. And the record will show that there are a number of accounts that these parties had in their separate names. The one that gives rise to this is Charles Schwab, account number 7299. The court did recognize that this was one of the accounts, but it failed to make any conclusions as to whether or not this was Mr. Parker's separate property or the court said it ended up being marital property, but there was no explanation as to why. Attached to Exhibit 33 are a series of checks that had been issued to my client by his brother, who was the trustee of their father's trust. And those represented insurance monies that Edward Parker the brother of my client explained to the court he received as trustee. And he sent those checks to my client. And it started, they were all done in 2009. The judge refused to recognize that those were gifts from the trustee to my client from the deceased father. I submit they represent the funds on deposit in the Schwab account ending in 7299 are separate properties of the appellant, John Parker. The other account that is at issue is it's set forth in Exhibit 33 and 33A.
And counsel, you have 5 minutes remaining. You may continue or reserve as you wish.
I'm sorry, Your Honor, I didn't hear you.
5 minutes remaining. You may continue or reserve as you wish.
Okay, I'm going to go for 2 minutes and then I'll sit down. Attached to Exhibit 33 are another series of checks issued by Edward Parker to his brother as corroboration of the fact that funds came from Frank. I'm talking about the wrong one. I'm sorry. It is my client's contention that he established by a preponderance of the evidence that the funds on deposit in account 38, in Exhibit 38 and 38A are his separate property. Those funds too came from Edward Parker on behalf of the father. During the father's life, the father had gifted monies to my client, and those monies were deposited first with his employer, then they went into life insurance policies for the benefit of the children. They were cashed in, and the monies went into his sister's account, and then by court order, those monies, $82,000, were placed in my trust account. We submit those are separate assets that belong to Mr. Parker. And I'll reserve 2 minutes.
Good morning. I'm Sunny Simon. I'm here on behalf of Pamela Parker, wife. May it please the court. With regard to the first assignment of error, 3105.18b grants a trial court the power to award reasonable spousal support upon the request of either party. In this case, it's very clear that Mrs. Parker made a specific request for spousal support on April 19, 2012 in a written motion to the court.
Did she make it in her complaint?
It was made in a motion, a specific motion requesting spousal support.
Did she amend the complaint?
She did not amend the complaint, Your Honor, but she asked for the spousal support in a motion. Further, Mrs. Parker specifically asked the court to equalize the parties' income in her motion. Once the request was made by Mrs. Parker, the terms and the requirements of the statute to satisfy, the analysis stops there. That's all the statute requires. The court has the power to award the spousal support. It does not have to be in a complaint. Furthermore, Rule 15b of the Ohio Rules of Civil Procedure supports this award as well. Rule 15b reads, when issues not raised by the pleadings, in this case they actually were raised in the pleading in a specific motion, when these issues are tried by express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings. Failure to amend, as provided herein, does not affect the result of the trial of these issues. Rule 15b supports the award of spousal support to Mrs. Parker. In addition, Mr. Parker was afforded due process in that, A, he had noticed that spousal support was an issue for trial, as it was raised in the motion, as well as in Mrs. Parker's pretrial statement that specifically raised the issue of spousal support and the reservation of jurisdiction on an issue. Secondly, Mr. Parker had due process because he had the opportunity to be heard at trial on this issue at trial. In fact, this court, in the case of Peters v. Peters, upheld the trial court's award of attorney fees in that case when the wife did not, A, request attorney fees by motion, Mrs. Parker did in this case, but also because Mr. Peters had the opportunity to be heard at trial in that case. In this case, the spousal support issues were tried fully. All factors set forth in 3105.18c were tried fully by the parties. Nobody from Mr. Parker to Mrs. Parker objected to any evidence coming in regarding...
Was there a request for a continuance or anything of that nature?
There was not a request for a continuance.
In other words, the parties were both prepared to go forward on that issue at the time.
The parties not only were fully capable and ready to go forward, they did go forward. The court went through by testimony. Mr. and Mrs. Parker testified. We had collateral witnesses as to the income of the parties, the relative earning abilities of the parties, the ages, physical, mental, and emotional condition of the parties. We went through duration of the marriage, retirement benefits, standard of living, relative extent of education, and the assets and liabilities of the parties. All of these factors were fully tried. Nobody asked for a continuance, and everybody participated fully with voluminous documents. Both parties submitted documents relating to employment, financial history, retirement accounts, all aspects of what was considered by this trial court, who specifically stated that all of these factors were considered in the award of support. With regard to the second issue, as it relates to spousal support, the trial court's award of spousal support to Mrs. Parker is supported by the factors in the 3105, but also is reasonable and appropriate. The courts explicitly referenced the relevant statutory factors it considered in its findings. According to Fisher v. Fisher, this is sufficient to uphold an award of support. As it relates to the trial court's finding that Mr. Parker had diminished earning income to avoid paying spousal support, that was supported by credible, competent evidence as well. The transcripts and the trial record will show that Mr. Parker was working 3 jobs at the time the divorce complaint was filed. He was working at Kuzman's, earning $52,000 a year, plus supplemental benefits for health insurance for his family. He worked his own business called App.No, where he had worked for years prior to filing for the divorce and during part of the divorce. And he also delivered produce to Copley School District. During the pendency of the divorce, Mr. Parker stopped working at App.No, his own business, which diminished his income.
What's the record on why he stopped doing that? Was the business gone flat? I mean, what is the context?
Mr. Parker just explained that he didn't want to work anymore at App.No. He didn't have time. After the temporary support order was issued, Mr. Parker started to slack off at his job at Kuzman and was fired from that job. Mr. Parker claims in his brief that it would be ludicrous to imagine him voluntarily being fired from that job and intentionally slacking off because he was under a temporary support award. However, as soon as he was fired, Mr. Parker came back to the court with a motion to reduce his support obligation, which the court did. The trial magistrate reduced Mr. Parker's support from $862 a month to $333. Mrs. Parker submits that this is an intentional act to avoid paying spousal support, and the trial court agreed based upon the evidence. Mrs. Parker raised the issue of imputation of income to Mr. Parker at the hearing on temporary support. The magistrate said that he would decline that request because there was no transcript of Mr. Parker's former employer's manager, Mr. Boda. With that, Mrs. Parker called Mr. Boda as a witness at trial. Mr. Boda testified specifically about Mr. Parker's declining work performance despite warnings. The trial judge was in the best position to hear testimony of the witnesses and to assess their credibility. As to Mrs. Parker's employment, Mrs. Parker's income did not dramatically decline, as did Mr. Parker. Mr. Parker was earning in excess of $52,000 a year, beginning of the divorce, and by the end was earning minimum wage. Mr. Parker's income as well, strike that, Mr. Parker never called Mrs. Parker's former employer to come in to testify as to the circumstances surrounding her separation from employment. She got a job and she earned close to what she was earning before. In terms of the child support, the trial judge was very clear that the award of spousal support was based on all statutory factors, one of them being earning capacity, relative earning capacity, which relates to the judge's finding that Mr. Parker had intentionally diminished his income. That's different from the standard upon which an imputation for child support purposes takes place. When a court imputes income for child support, it must find that a party was voluntarily underemployed or unemployed. That's not the case with spousal support, and the judge in the trial court was very clear about that the award of support was based not only on the diminished earning capacity of Mr. Parker, but based on all the statutory factors which the court considered and all parties participated in hearing.
Well, capacity counsel would tend to mean your level of education, correct? Your experience, any education you might have in trades. Not necessarily what you're earning, or it might also be health. Wife has a college degree, correct?
Yes,
And she works and has worked in a managerial position, correct?
she was, yes.
Husband has a high school diploma, I'm assuming,
In some college,
and some college, okay?
correct,
Does the record reflect that?
yes.
Okay. His prior employment, either from Parker and Sons or from Cushman's, was that a labor-related employment, or was that a supervisory employment, a management type of position that he had when he worked for the?
Kuzmin's was sales. He was a desk job and cold calling, so he's done all of the above. Sales and labor, both. In terms of the third assignment of error, and I would just admit there's no conflict, the judge was very clear about the basis upon which the court was awarded. Lastly, with regard to these two accounts that the court found were marital, the record is clear that Mr. Parker failed to meet this burden of proof by preponderance or otherwise, that either the Schwab account or the insurance account were separate property. The court did explain why it held that these accounts were marital. Mr. Parker never produced a shred of evidence that the 3 checks he produced from his father's trust were ever deposited into that Schwab account, ever. In fact, Mrs. Parker produced bank records showing contrary evidence that Mr. Parker ended up depositing these 3 checks into a first merit account, which, by the way, he claimed was some account he never disclosed, but Mrs. Parker was able to show that the 3 checks went into this first merit account, commingled with marital property, and over time, Mr. Parker withdrew cash. Never once did we see a traceable shred of evidence other than some speculative testimony that this went into Schwab. It just can't hold up at all. There's nothing showing they ever went to Schwab, and that goes as well for the Union Security Policy accounts where Mr. Parker claimed money was gifted from his father. The policies were funded from 2001 to 2011. Mr. Parker's dad died in 2008. Furthermore, there's no evidence at all that, first of all, Mr. Parker received gifts from his father. There's no receipts, there's no gift tax returns, there's no evidence at all that he received money from his father.
And the brother was trustee of this?
The brother
was trustee. Did the brother testify and provide any of the evidence that you're saying is not before the court?
The brother testified that the 3 checks we talked about that supposedly went into the Schwab account came from the father's trust. And also testified under cross-examination that he knew nothing about these policies of insurance that were being funded by the father at $800 a month. So the brother affirmatively testified that he knew nothing about this and never testified that Mr. Parker received $800 a month from this account. He never did. We only saw 3 checks and some testimony about cash, which got clouded because on the one hand they said this money went into the Schwab account, but then on the other hand they were saying there was sufficient money coming from this trust, which we never saw.
Were those 3 checks drawn off of the father's trust account?
Yeah, we saw the checks. There's 3 checks.
They're all from the trust account?
Yeah. Mr. Parker never produced anything showing that these policies were funded from his father. I mean, he has to do more than just testifying to that. In fact, Mrs. Parker went through the trouble of finding evidence that these premiums were being paid by Mr. Parker's employer, Parker and Sons, at the time, as part of his job and during the marriage. So this was all being funded, these accounts, these policies during the marriage. The record's also clear that Mr. Parker kept this account secret from Mrs. Parker. And 3 months prior to filing for divorce, he took this account and put it into his sister's name. It was only through the course of discovery and trial that Mrs. Parker was able to discover this account even existed. Clearly it was paid through marital funds, and especially when we know Mr. Parker's dad died in 2008, there was no money coming in other than through Mr. Parker's employment. Mr. Parker could have called his former employer to testify that Mr. Parker was giving cash, as he stated, to his secretary there to fund these policies. He never bothered calling any witnesses from an employer, and by the way, they were available because Mrs. Parker was in contact with them. So we know they were available to testify, but it was very glaring that Mr. Parker never bothered to bring them in because they would have been the ones to ascertain this claim that he was taking cash from some gift from his dad, which we have no evidence of, took cash out of his pocket, gave it to a secretary at his former employer, never got a receipt, never had any proof of this. This is a lot of money, $800 a month, to have no record of. And the secretary allegedly paid off these policies. So it's not enough for Mr. Parker to say something is true. He needs to provide credible evidence to be able to uphold the burden of proof that he has. There's competent, credible evidence supporting the court's finding these accounts were marital and should be divided equally between the parties. That's fair, that's just. And if there's no further questions, then rest.
Thank you. Counsel, you have about 3 minutes and 40 seconds remaining.
Thank you, Your Honor. I would just emphasize that plaintiff's exhibit 33 and appellant's exhibits 33 and 38 and 38A both have checks attached to them. Edward Parker testified as to why these checks were issued to John Parker. They represent his separate property. Any suggestion by counsel that John Parker became voluntarily unemployed when Kuzman discharged him is ludicrous. Throughout the entire marriage, Mr. Parker worked at J. Parker and Sons. It's a wholesale produce distributor here in Copley. And that produce was loaded onto trucks and they were sold. Their biggest customer was Acme. Parker and Sons lost Acme, and they started to let people go. And that's why, after many years, John Parker, who was not related to anybody at Parker and Sons, went to work at Kuzman's. He lost his job at Kuzman's, and it's in the record, because the employer said because of poor performance. Part of the poor performance was that he had to come to court and do things over and over again, and they did not like that.
He didn't work on commissions,
He did not.
he worked on a salary.
Yes.
Wasn't it also that he didn't show up in the morning on time, that he left early?
He had to be there at 4:30 in the morning.
It's produce.
Yeah. And sell it, and then he would get off in the middle of the afternoon, but he had to leave home and be there at 4:30 in the morning.
Isn't that what he was doing for Parker and Sons as well?
Yes, so he didn't have to be there at that time. He is not voluntarily underemployed or unemployed. The other jobs that he had that counsel made reference to, by delivering produce to Copley, he couldn't do that anymore and work at Kuzman's. He had to give it up. The Deck Pro job was formed by him to earn extra money for the family so that he could fund payment of one of his daughter's activities away from home, where they went as a family to participate in events with hotels and meals and everything like that. So physically, he could not do the three things that counsel makes reference to. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be known to both sides, as well as posted on our website and the Ohio Supreme Court website. Thank you.